20 minutes before 7 o'clock here on Morning Live. Welcome. The Labour Relations Amendment Act is to be implemented no later than the 1st of April 2015. There are several issues that will be dealt with pertaining to trade organisational rights, the election of shop stewards, the right of representation of employees during disciplinary inquiries, and the use of fixed-term contracts, amongst other issues. Today we have in studio with us Attorney Osborne Malatudi from Cowan and Harper Attorneys to tell us a little bit more about this. Thank you so much for being with us. It's a pleasure having you on the programme.
Thank you, Leanne, and thank you for the opportunity.
All right, please share with us which Labour Amendment Acts have been passed into law so far.
Basically is the Employment Equity Amendment Act, the Basic Conditions of Employment Act, and the important one called the Labour Relations Amendment Act.
Yeah. All right. So those acts, how are they going to affect us?
They will, one way or the other, affect us, all of us, companies and workers. And just for clarification, the Labour Relations Amendment Act became effective 1st of January 2015. While some of us were on holiday, the President signed that into law.
Yeah.
So they will affect us, particularly in areas of fixed-term contracts, part-time employees, temporary service, rights that can be given to trade unions, yes.
Okay. Let's go broader than that, because I'm sure a lot of people are not, like you say, we were on holiday when this all happened, and we may not be aware that we have more rights now than we ever had. So what are the differences in terms of our contracts when you're talking about those laws that have come into effect already?
I think the one Amendment Act that will receive more attention is the Labour Relations Amendment Act, because it contains very important provisions relating to temporary service, part-time employees, fixed-term contracts, and more specifically, as the trade unions have demanded, a ban on labour brokers. And the Labour Relations Amendment Act contain what we see as win-win provisions, in that as much as there's no outright ban of labour brokers, there is going to be restrictions on how employers could make use of temporary employees, fixed-term contracts, as well as part-time employees.
Yeah. So obviously it is better for the labour market, what you're talking about.
I would say yes and no, because the Labour Relations Amendment Act contained deeming provisions. So if someone works for a client of a labour broker for longer than 3 months, that person will be deemed to be an employee of the client.
Yeah.
So most companies may be reluctant to continue making use of labour brokers, and consequently labour brokers, the business of labour brokers might be affected, and to the extent that they may even be forced to shut down. Yeah. Part-time employees, they have to be treated on the whole the same way as what the Act defines as comparable full-time employee, especially if they do same or similar work. And also they have to have access to similar opportunities like training, job vacancies, and related.
Yeah. Okay, so these have all become rights now that part-time employees have never had before.
Yes, and just to clarify, all of these key amendments apply to employees who earn below what you call ministerial threshold, currently being 205,433, I think some couple of cents. But what it means is that any employee who earns in excess of that amount will not be subject to the provisions of these key amendments.
Okay, so but anybody earning just below 205,000 a year, is that correct?
Yes.
Okay, is eligible for this?
The amendment acts are primarily aimed at what is classified as vulnerable employees. And that is why they've been structured in the manner in which they've done. For instance, there's also a key amendment on equal pay for work of equal value. That will also have significant impact on employers and employees in the workplace. The other significant amendment relates to minority trade unions. They can be given certain limited rights, which, for instance, representing their members in the workplace, at inquiries, electing shop stewards, etc. So gone are the days where only majority trade unions rule. There can be certain rights that can be given to minority unions. There are significant amendments, and it's for this reason that we'll be dealing with them in our client workshop on 5 February 2015. Okay. There's a whole series of them. Unfortunately, maybe due to time constraints, one won't be able to go through all of them.
I think it's something we need to do in terms of an insert so that people can actually understand it better. Just very quickly, and our last question, if you can answer this quite quickly. Trade brokers, labour brokers, you spoke about this, but obviously trade unions want to, their sort of aim is to ban them completely. What's happening with them now? You mentioned it briefly.
Yes, there will be a legislation that will regulate the operations of labour brokers, and that legislation is yet to be drafted. But essentially, they have to convert into service providers and not just provide labour to employers. They have to provide something more than just labour. By way of an example, if you ask someone to build a wall, he must do that. But if you ask someone to provide you with workforce to build a wall, it's a different story. Yeah. So there will be law that will be passed to regulate the operations of labour brokers.
All right. Thank you for joining us. Thank you for unpacking some of those details for us here on the program. Attorney Osborne Malatudi, who is from Cowan and Harper Attorneys, talking to us about some of these labour relations amendments that have come into effect and others that are coming into effect on the 1st of April 2015. We certainly will do more on that. And I think an insert will really, just to give you some practical examples, will help quite a lot. Thank you again.
My pleasure.
All right. Let's take a break.